Good morning and welcome to all our attendees this morning. My name is Kelly Robreno Koster. I'm a partner at Bracewell in the Labor and Employment Group. And with me this morning is Associate Caroline Melo Chapman. And we are excited to speak to you this morning about compliant hiring, your current legal obligations when building your workforce. Because we understand that building a diverse and productive workplace is a challenge in and of itself without also having to keep in mind various legal requirements and obligations that you as an employer may have. With an increasing number of laws around hiring on the state level and employers increasingly expanding their workforces across state lines, either from physical growth or remote growth or changes to your footprint, the vast number of laws and legal implications an employer has to keep in mind is overwhelming, and the changes are dynamic. We are hoping today to provide you with a roadmap of some of the legal requirements and best practices an employer must or should comply with when hiring an employee. For each of these items, it's important to consider any applicable state and local laws. While we will cover some notable state laws today, we obviously cannot cover them all. Please keep in mind where your employee is actually working and not just the office to which he or she is assigned. And with that, we'll turn it over to Caroline for our first topic, equal pay laws and pay transparency. Caroline?
Thanks, Kelly. The first topic we're going to talk about today is equal pay, or more specifically, pay transparency, and the effect that these laws have had on job postings and job applicants. In recent years, a number of states and localities have passed laws that prohibit asking an applicant about their compensation history or relying on that compensation history when setting a new hire's wage or salary. There have also been a number of lawsuits on this issue. For instance, the Ninth Circuit held that employers cannot use prior pay, quote unquote, alone or in combination of other factors as a defense to an equal pay claim under the Equal Pay Act. These laws seek to effectively combat pay discrimination, especially for females, minorities, and other individuals in protected groups, some of which may have started their careers at lower salaries or wage rates. At least 22 states have enacted some sort of compensation history ban, many with municipalities following suit. You can see the list of states here up on the PowerPoint slide. A few of them are California, Connecticut, D.C., Maine, Maryland, Nevada, New Jersey, New York, Pennsylvania, Vermont, Virginia, and you'll see a little asterisk next to some of those. Those are ones where the law actually only applies to state agencies, not private employers. And then we actually have Michigan and Wisconsin that have passed laws prohibiting salary history bans in those states. A few examples of cities with compensation history bans are New York City, Cincinnati, and Philadelphia. Practically speaking, even if you are in a state that does not outlaw asking an applicant's salary history, you likely want to consider taking any salary history question off your applications, as these prohibitions are becoming more widespread. We are often seeing our clients and many employers that we are familiar with remove these questions altogether. In 2018, California amended its equal pay law to require employers to provide a position's pay scale, which is the salary or the hourly wage range, to applicants who made a reasonable request for this information. Several other states following California passed similar laws, for instance, Connecticut and Maryland. In November 2020, however, Colorado redirected the course of pay transparency laws and amplified the requirements and obligations that employers are supposed to meet. Under the Colorado law, employers had an affirmative obligation to disclose positions' pay in a job posting without a request from an applicant. Subsequently, a number of states amended their pay transparency laws or even passed new laws requiring employers to disclose salary and pay ranges and sometimes even benefits in job postings. Many of these laws also have various record retention requirements. There are currently 15 states with some sort of pay transparency law. These all kind of slightly differ, but have the same purpose: to provide transparency about pay to job applicants, as well as internal employees that are maybe seeking to switch jobs or get a promotion. Obviously, we cannot cover all 15 of these laws today. That would be a webinar within and of itself. But we are going to talk about two notable state pay transparency laws, California and New York. California passed SB 1162, which became effective January 1st, 2023. Under that law, employers are required to, one, include pay scales in each of their job postings, but two, to also report how much certain groups of employees are paid. So the disclosure obligation in job posting applies to California employers with 15 or more employees. The pay data reporting obligation has a bit of a higher threshold. It applies to California employers with 100 or more employees, but then it also applies to California employers with 100 or more workers hired through labor contractors. Under SB 1162, pay scale is defined as the salary or hourly wage range that the employer reasonably expects to pay for the position. And compensation and benefits, bonuses, tips, etc., provided in addition to a salary or hourly wage range are not required to be disclosed in the posting, but may be voluntarily provided. That is something that is different that you'll see among other different state laws. The California law also applies to remote work positions, meaning a pay scale must be included in a job posting if the position may be filled in California, either in person or remotely. We're often seeing clients make judgment calls here because obviously, technically, any remote job could potentially be filled in California. So there is a little bit of some judgment that needs to be made. Certain wage records must also be retained for 3 years. As for the reporting obligation, the report that employer must submit must include the number of employees by race, ethnicity, and sex in certain job categories and pay bands, and it must be submitted to the California Civil Rights Department annually. These reports are then published by the department for the public to view. A separate report must also be submitted for contract workers. And under this law, aggrieved individuals can file complaints with the Labor Commissioner's office within 1 year of the injury, and aggrieved individuals can also bring a private right of action. The next law we're going to talk about is New York's pay transparency law, which is New York Labor Law 194B. Under 194B, employers are required to include, quote unquote, the compensation or a range of compensation and job description, if one exists, in any advertisement for a job, promotion, or transfer opportunity. This applies to jobs, promotions, or transfer opportunities performed at least in part in the state of New York, or that are performed physically outside of New York, but report to a supervisor, office, or other work site in New York. So this is a little bit different than the jobs covered under the California law. Range of compensation is defined as the minimum and maximum annual salary or hourly wage range of compensation that the employer, in good faith, believes to be accurate at the time of posting. New York Labor Law 194B applies to New York employers with at least 4 employees, and there's no record-keeping requirements under this law. There's no private right of action, but aggrieved individuals may file a complaint with the state labor commissioner. Note that there's also a pay transparency law in New York City under the New York City Human Rights Law. This also involves pay transparency, and so employers in New York City should look to both New York State, New York City, and follow the most stringent law. In New York, or in New York City, interestingly, there is a private right of action for employees, but not for applicants. And this is arguably to quell, quote unquote, applicants from trolling for non-compliant postings and applying purely to bring a claim. So while we've only talked about 2 state laws today, it's important to note that pay transparency is a growing trend across the country. As mentioned, there are currently 15 states with pay transparency laws on the books. 5 of those states have pay transparency laws becoming or that have become effective in 2025. Those states are Illinois, Minnesota, Vermont, Massachusetts, and New Jersey. Illinois and Massachusetts became effective January 1st, 2025, while the other states will follow later this year. Note that there is no pay transparency law in Texas. As more states pass pay transparency laws, we are seeing employers decide if they want to take a piecemeal kind of state-by-state approach to these job postings, or if they want to follow a more applicant employee-friendly approach and apply these pay transparency requirements to all job postings around the US. There's pros and cons to doing both of those things. And as many of these laws are similar to each other, they do all have several differences and little intricacies that are important to note, especially if you're going to take a US-wide approach. Back over to Kelly.
Thanks, Caroline. In this section of the webinar, we'll be covering background checks broadly, including the Fair Credit Reporting Act, the EEOC's green factors, reference checks, and social media checks. Before we get into the Fair Credit Reporting Act and the various relevant state laws, it's important to remember that there are also industry-specific laws that require background checks for dangerous or safety-sensitive jobs. We will not be focusing on those laws today, but we wanted to highlight this additional requirement for employers for whom it may be relevant. There are several reasons employers conduct background checks during the hiring process. Number one, and the most obvious, is to reduce liability. An employer can be exposed to liability if an employee causes harm that could have been avoided by appropriate pre-hire due diligence. These claims may be brought under several legal theories, including respondeat superior, which is when an employer is subject to liability for the acts of their employees. An employee must act within the scope of his or her job duties and for the employer's business purposes. Another theory is negligence, including negligent hiring, negligent retention, or negligent supervision, which is when an employee acts outside the scope of his employment so that respondeat superior does not apply. A plaintiff may attempt to hold the employer accountable on grounds of independent negligence. Another reason that employers may do background checks may include reducing employee theft and workplace violence. For example, if an employee has a history of violent conduct, that may be relevant to whether you want to hire this person. And likewise, you'll want to confirm the accuracy of the applicant's credentials. Very, very important note is that a background check should only be done after a conditional offer of employment. The national federal law that governs the collection and dissemination and use of consumer credit information is the Fair Credit Reporting Act, also known as the FCRA. The FCRA regulates employer background checks when obtained through a third party, such as a consumer reporting agency. A consumer report means any written, oral, or other communication of information by a consumer reporting agency bearing on a consumer's credit worthiness, credit standing, credit capacity, personal characteristics, or mode of living. And it's used or collected for eligibility for credit, insurance, employment purposes, or another purpose as enumerated under the Act. Consumer reporting agencies is any third-party service provider that conducts a background check. The FCRA places limitations on consumer reports when they are used for employment purposes. Employment purposes, when used in connection with a consumer report, means a report that is, as the name implies, used for the purpose of evaluating a consumer for employment, promotion, reassignment, or retention as an employee. And here is where compensation thresholds become relevant. For jobs that pay less than $75,000 annually, and this is both for hourly employees if their compensation is annualized or for salaried employees, the following information must be excluded from a report and cannot be considered by the employer when requested for employment purposes. Chapter 11 bankruptcies that are more than 10 years old, civil lawsuits, civil judgments, and arrest records more than 7 years old. Note that in many states, arrest records cannot be considered at all. Paid tax liens that are more than 7 years old, delinquent accounts more than 7 years old, or other adverse information other than criminal convictions that are more than 7 years old. It is a common misconception that under the FCRA, there is a 7-year reporting limit on criminal convictions, and that is not true. There is no time limit for reporting information on criminal convictions. The FTC says that the FCRA covers consumer reports with independent contractors but courts are split on this issue. Employer obligations under the FCRA include notice, disclosure, and consent requirements when using consumer reports for employment purposes. Before obtaining a report for employment purposes, an employer must notify the individual and obtain written consent. The notification must be an easy-to-read document and include only the FCRA notice. In other words, it cannot address other topics in the same notice. Taking an adverse action, which is the denial of employment based on the consumer report, there are additional requirements that must be met by the employer. First, the employer must provide what we call a pre-adverse action, which is giving the individual a copy of the consumer report and a written summary of the consumer's rights under the statute. While no specific time is specified under the FCRA, an employer should give the individual, quote, a reasonable amount of time to respond to the report before the final adverse action is taken. The FTC has found that 5 business days is typically sufficient. There also may be times when the individual has an explanation that may change whether the employer wants to take adverse action, and you want to give them sufficient time to provide that reasoning. If the employer decides to proceed with the adverse action even after giving the applicant or employee the pre-adverse action letter, there are post-adverse action disclosures that must be provided, including the following information: the notice of the adverse action that the employer is taking, notice of the individual's credit score, contact information for the consumer reporting agency, a declaration that the consumer reporting agency cannot provide specific information about the reasons underlying the adverse action, notice of the individual's right, typically within 60 days, to request and acquire another copy of the consumer report at no charge from that consumer reporting agency, and notice of the individual's right to contest the contents of the consumer report with the consumer reporting agency. If an employer obtains a report with negative information, but decides to make an employment decision for reasons unrelated to the report's contents, it is still good risk management practice to provide the investigated individual with a copy of the report, a notice of his or her rights, and an explanation that the report's contents were not relevant to the employment decision, even though the employer pulled the report. Unlike some of the laws that Caroline described, the FCRA does provide for a private right of action, meaning that an aggrieved individual may sue the employer directly, and also enforcement by the FTC or a related federal agency. However, damages to individuals are typically capped at $1,000 per violation. Civil penalties for actions brought by the FTC are currently set at $2,500 per violation. However, courts may impose compliance monitoring, reporting, and record-keeping obligations if you are hit with a civil penalty. Keep in mind that any employer who violates the FCRA once has often committed the same violation numerous times as a matter of practice, so it is important to audit your background check practices to ensure that your policy is compliant. Keep in mind, even if you do the background checks in-house, you need to obtain written consent before initiating a background check to minimize a potential privacy claim. As I mentioned at the top of this section, in addition to the FCRA, a lot of states have their own equivalent FCRA law, and Texas is one of those states. Texas background checks are regulated by the Texas Business and Commerce Code. For jobs that pay less than $75,000 annually, a consumer reporting agency is prohibited from furnishing the following information to employers: a bankruptcy matter in which the order for relief was more than 10 years ago, a suit or judgment entered more than either the length of the governing statute of limitations or 7 years before the consumer report, a tax lien in which the payment date is more than 7 years old, an arrest record, indictment, or conviction of a crime in which the disposition, release, or parole occurred over 7 years ago. Note that the 7-year limitation does apply to criminal convictions under Texas law, unlike federal law. Many of the definitions under Texas law mirror definitions under the FCRA. However, there is that significant departure in that old criminal convictions cannot be considered. Also, in Texas, minor convictions and arrests cannot be considered. And now I'll turn it over to Caroline to talk about the Equal Employment Opportunity Commission's green factors.
Thanks, Kelly. In addition to the FCRA and state law limitations, employers should also consider what the EEOC calls the green factors and other applicable EEOC guidance when making an employment decision based on criminal history. The reason is that when an individual is excluded from a position for criminal history purposes, there is risk that the individual could bring a discrimination claim, for instance, a disparate impact claim under Title VII. The Eighth Circuit in Green versus Missouri Pacific Railroad identified 3 factors that are relevant in establishing whether an exclusion from a job is job-related and consistent with business necessity, therefore strengthening the employer's defense that it took action in a legitimate, non-discriminatory manner, meaning it did not discriminate against the employee. Those 3 factors are as follows. 1, the nature and gravity of the offense or conduct. 2, the time that has passed since the offense or conduct and or the completion of the sentence, and the nature of the job held or sought. The EEOC, in its published guidance, has also made clear that employers will consistently meet the job-related and consistent with business necessity defense if the employer develops a targeted screen considering at least the nature of the crime, the time elapsed, and the nature of the job, which is the green factors, and then provides an opportunity for an individualized assessment for people excluded by the screen to determine whether the policy is applied, is job-related, and consistent with business necessity. Other relevant individualized evidence to consider in the individualized assessment per the EEOC includes the facts or circumstances surrounding the offense or conduct, the number of offenses for which the individual was convicted, older age at the time of conviction or release from prison, evidence that the individual performed the same type of work post-conviction with the same or a different employer with no known incidents of criminal conduct. 5, the length and consistency of employment history before and after the offense or conduct. 6, rehabilitation efforts, for instance, education and training. 7, employment or character references and any other information regarding fitness for the particular position. And 8, whether the individual is bonded under a federal, state, or local bonding program. The EEOC also makes clear that if an individual does not respond to the employer's attempts to gather additional information to make this individualized assessment, the employer may make its employment decision without that information. But then the EEOC guidance also suggests that if an employer successfully demonstrates that its policy or practice is job-related for the position in question and consistent with business necessity, a Title VII plaintiff may still prevail by demonstrating that there is a less discriminatory alternative employment practice that serves the employer's legitimate goals as effectively as the challenged practice, but the employer refused to adopt. The main reasoning behind the green factors is to make sure that you're taking an individual look at each applicant or employee that you're considering their criminal history background when making a decision. In addition to the green factors, I want to discuss the EEOC's views on arrests and convictions. The EEOC's view is that there's a difference between arrest and conviction records. Arrest records do not establish that criminal conduct occurred. However, the EEOC does say that an employer may make an employment decision based on the conduct of the underlying arrest if the conduct makes the individual unfit for the position. In addition to background checks, it is also best practice to obtain reference checks and employment references from previous employers. There's numerous reasons to do this. You may want to confirm past employment or hear from a past supervisor if the individual is qualified for the position in question. However, it's very important that employers should not contact a previous employer unless the applicant has indicated that they can be contacted, especially if the applicant is still working at that employer. Be aware, though, that some employers, as a policy, only give neutral references. For instance, they only confirm an individual was an employee and dates of employment. So if someone provides that to you, don't assume that it's a negative reference just because they're not giving you more information. In addition to reference checks, I want to take a moment to address social media checks. We're increasingly seeing employers wanting to conduct social media background checks. This may be through a third party or through human resources or recruiting or simply Googling the employees or searching for the employee on different social media platforms. Supervisors or hiring managers may also be looking at the applicant's social media as well. Some states, in response to this, have passed social media privacy laws applicable in the employment context. While we don't have time to get into all these laws and all the specifics, many of these laws restrict employers from requiring an applicant to provide their username or their password, or requiring the applicant to provide you with observation of their personal internet account. While there are no laws against viewing an applicant's public social media account, for instance, if their profile is public, there is still risk in viewing an applicant's publicly available social media. Specifically, if an employer views an applicant's public social media and discovers a particular protected characteristic or activity, for instance, the applicant's race, sex, gender identity, maybe that they've engaged in protected lawful off-duty conduct, the employer no longer has a defense of ignorance if a discrimination claim is brought against the employer by that applicant. In order to mitigate risk, what we've seen is many employers hire third-party organizations to perform social media background checks. These organizations, to the extent possible, can often redact information about an applicant's protected characteristics or activity. That third party, though, will be considered a consumer reporting agency. So the employer and the reporting agency will need to comply with all the various notice, consent, and other procedural requirements of the FCRA and any equivalent state laws. Another option that we're also seeing is employers kind of designating a centralized individual or team within the employer that is separate from the decision makers, separate from any supervisors or managers who conduct the social media background checks. It's important, though, when determining whether, as an employer, you want to undergo these checks, is to understand why. Why are you conducting the social media background check? And what information will you get that is going to be useful to you at all during the hiring process? Most importantly, supervisors and managers should not be conducting social media background checks and should be instructed to not conduct such searches. Before moving on to our next topic, I want to talk about the practical considerations of background checks. It's important to limit access to background check information. Only individuals on a need-to-know basis should have access to the background check information. Supervisors and managers generally should not have access to this information or be informed of it, unless there is a specific reason for them to know. For instance, there may be a situation where a supervisor needs to know certain criminal background information, for example, in order to determine whether criminal history would prevent the employee from adequately and safely performing the job. It's also important to consistently treat applicants' employees the same in regards to background checks. Treatment should be consistent when performing background checks. They should not be performed only on some applicants and not others, but how the background checks affect whether a job offer is made can and will vary based on the specific job. And remember, the green factors call for an individualized assessment.
Thanks, Caroline. Now we're going to talk about ban-the-box laws, which are sometimes called fair chance laws, and add additional limitations on when you can pull and rely on criminal histories. So ban-the-box laws restrict employers from inquiring about an applicant's criminal background at various stages of the hiring process. The laws are designed to ensure fair hiring practices and provide a second chance for individuals with a criminal history. These laws generally prohibit asking an employee about their criminal history on an employment application, but laws do vary based on the jurisdiction. Some laws are more focused on banning inquiries regarding arrests as opposed to convictions. There is no federal ban-the-box law applicable to private employers. The Fair Chance Act, which was signed into law in 2019, applies only to federal government agencies and contractors. Likewise, Texas has no state-level ban-the-box law, but some localities, such as Austin, does have a ban-the-box law. Some states with ban-the-box laws are California, both statewide and in various cities, Colorado, Connecticut, D.C., Hawaii, Illinois, Louisiana, Maine, Maryland, Massachusetts, Minnesota, New Jersey, New Mexico, Oregon, Rhode Island, Vermont, Virginia, Washington, and Wisconsin. A non-exhaustive list of cities with ban-the-box laws are LA, San Francisco, San Diego, New York, Atlanta, Chicago, Baltimore, and as previously mentioned, Austin. If an employer is recruiting from multiple states, that employer may want to consider removing criminal history questions from their applications. Another pre-hiring or post-offer consideration is drug and alcohol testing. And drug and alcohol testing also comes up during employment. So it's important to understand the various requirements at the various stages. There are some industry-specific drug testing laws that are applicable to employers during a hiring process, but we will only be discussing federal and local laws today. Employers actually have considerable latitude under federal law to maintain an alcohol and drug-free workplace. This latitude, however, is balanced with the Americans with Disabilities Act and applicable state law. For instance, drug testing an applicant for employment may reveal the applicant has a disability, which would then trigger rights and protections under the ADA. Further, under the ADA, tests for alcohol are medical examinations, while drug tests are not. This dictates when and under which circumstances the testing can take place. As a reminder, an employee's ability to make disability-related inquiries or require medical examinations is analyzed in 3 stages: pre-offer, post-offer, and during employment. At the first stage, or prior to an offer of employment, the ADA prohibits all disability-related inquiries and medical examinations, even if they are related to the job. At the second stage, or after an applicant is given a conditional offer, but before the applicant starts as an employee, an employer may make disability-related inquiries and conduct medical examinations, regardless of whether those inquiries are related to the job, as long as it does so for all employees entering the same job category. And lastly, at the third stage, during employment, an employer may make disability-related inquiries and require medical examinations only if they are job-related and consistent with business necessity. Because drug testing is not a medical examination under the ADA, the 3-stage framework does not apply. Therefore, federal law does not generally prevent employers from conducting pre-employment drug testing, but there may be privacy laws to consider. There are also a number of state laws that will govern this practice, and we'll talk about at least one of those later in this programming. For alcohol testing, an employer must consider the ADA framework, and if it chooses to do so under federal law, only alcohol test applicants after a conditional offer of employment, and only as long as it does so for all employees entering the same job category. The ADA also does not make a distinction between marijuana and other Schedule I drugs in regards to employer testing, but some state laws do. As a reminder, marijuana is currently illegal under federal law, but not under all state laws. In some states where marijuana is legal, laws have been enacted to protect both medicinal and recreational marijuana users. One of the states that departs from federal law is California. For instance, in California, where recreational marijuana is legal, employers cannot discriminate against applicants and employees for their off-duty, off-site cannabis use. So while California employers may still conduct pre-employment drug testing, they can only use tests that look for psychoactive compounds in cannabis, which is what makes an individual impaired. The typical types of tests used for drug testing, such as urine, saliva, and hair tests, only test for the non-psychoactive compounds and do not show current impairment. While there are tests currently being developed to test for the psychoactive compound found in cannabis, we have not seen these tests yet actively used in compliance with California law. Thus, there is currently, that we're aware of, no test on the market that would allow for practical pre-employment drug testing of marijuana in California. And now I'll turn it over to Caroline to talk about the strategies to mitigate bias in hiring.
Thanks, Kelly. In addition to the laws discussed today, there are strategies employers can implement during the hiring process to mitigate bias and therefore, hopefully, decrease discrimination claims. One thing employers should do is they should train employees and managers who are conducting interviews. It sounds simple, but it's something that's very important. Employees and managers conducting interviews should be trained on anti-discrimination laws and bias that may arise during the hiring process. On a basic level, managers should be trained on questions really not to ask during interviews. For instance, an interviewer should not ask an applicant about their disability or their marital or parental status or any other type of question that could elicit information about a protected classification. Really, the guiding principle here is questions should focus on the job, not the candidate's personal details. For example, you can ask, do you require sponsorship, but not, are you a citizen? You can ask, are you able to work the posted hours, but not, how far do you live from the office, or are your kids in daycare? You also want to standardize interview questions. While this may not be practical for all jobs during the hiring process, it's best practice to ask the same questions in the same order when interviewing candidates for the same job. This helps eliminate different biases. For instance, affinity bias, which means having a more favorable opinion of someone like you. For instance, maybe someone of the same race or someone who went to your same high school or college or grew up in the same neighborhood or reminds you of your younger self. Another strategy that we're seeing employers do is examine and rework their job descriptions. Are there certain words that may have an underlying bias or result in certain protected groups not applying for the job? There was research out of Harvard that showed that masculine language, including adjectives like competitive and determined, resulted in women perceiving that they would not belong in that workplace. On the other hand, words like collaborative and cooperative tended to draw more women into the workplace. I'm going to pass it over to Kelly to talk about diversity, equity, and inclusion policies.
Now we want to address the current landscape of DEI policies and how they may affect hiring in light of the recent actions taken by the Trump administration. Specifically, President Trump issued several executive orders in his first weeks in office addressing DEI initiatives in the federal government. On January 20th, President Trump issued Executive Order 14151 titled Ending Racial and Wasteful Government DEI Programs and Preferencing. According to the text of the executive order, the purpose of the executive order is to rid the government of diversity, equity, and inclusion programs within the government. The executive order directs the director of the Office of Management and Budget, assisted by the Attorney General and the director of the Officer of Personnel Management, to coordinate the termination of all, quote, discriminatory programs, including DEI and DEIA programs under whatever name they may appear. According to the same executive order, to carry out this directive, the director of the OPM, with the assistance of the Attorney General, must review and revise all existing federal employment practices, union contracts, and training programs and policies to comply with this order. Further, each agency, department, or commission head must terminate to the maximum extent allowed by law all DEI and environmental justice offices and positions, all equity action plans, initiatives, or programs, any equity-related grants or contracts, and all DEI performance requirements for employees, contractors, or grantees. These agencies, departments, and commission heads must also provide to the director of the OMB a list of all DEI positions and programs that were in existence on November 4th, 2024, and an assessment of whether these positions programs have been renamed in an attempt to preserve the function. The heads must also provide a list of federal contractors who provide DEI training or DEI training materials to agencies and a list of federal grantees who received federal funding to provide or advance DEI or, quote, environmental justice programs. While this executive order focuses more on eliminating DEI programs and positions in the federal government, it provides a flavor of the administration's goals in terms of DEI and its motivation to identify DEI programs that are being renamed or retained under another name. On January 21st, President Trump issued a second executive order related to DEI entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. While this executive order also focuses on the federal government and cutting DEI programs from federal agencies, there is more potential to impact private employers under this order. For instance, this executive orders, quote, all agencies to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. This EO rescinded several executive orders previously focused on DEI. For example, President Lyndon Johnson's 1965 executive order that required federal contractors to give equal opportunity in hiring and to submit affirmative action plans. Under the new executive order, federal contractors now must instead, in federal contractors, quote, certify that they do not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. The executive order further states that within 120 days of the order, the administration must, quote, submit a report containing recommendations for enforcing federal civil rights laws and taking other appropriate measures to encourage the private sector to end illegal discrimination preferences, including DEI. The report must include a proposed strategic enforcement plan identifying A, key sectors of a concern within each agency's jurisdictions, B, the most egregious and discriminatory DEI practitioners in each sector of concern, C, a plan of specific steps or measures to deter DEI programs or principles, D, other strategies to encourage the private sector to end illegal DEI and preferences and comply with federal civil rights laws, E, litigation that would be potentially appropriate for federal lawsuits, intervention, or statements of interests, and F, potential regulatory action and sub-regulatory guidance. As part of this strategic enforcement plan, each agency shall identify up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations or associations, foundations with assets of at least $500 million, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. Even in light of the language targeting DEI programs in the federal government and in the private sector, private employers must remember that anti-discrimination laws still control. Executive orders do not have the power to change civil rights law. For example, Title VII of the Civil Rights Act of 1964 still controls. Even despite the executive orders, a private employer's DEI programs always need to comply with the law, and it is no different now, even after these executive orders. Accordingly, all policies or practices aimed at preventing discrimination in the workplace should not necessarily be paused or discontinued. What these orders do tell us, however, is that private employers with DEI programs may be subject to increased scrutiny and legal challenges, meaning private employers should examine their current DEI programs if they wish to continue them and ensure they comply with civil rights laws. In addition to these executive orders, both the Attorney General and Office of Personnel Management have published memoranda regarding the executive order and targeted DEI programs. The Attorney General's memorandum outlines the components of the pending report required by the new executive order. The OPM memorandum touches on several DEI-related items, but specifically in the context of federal workers. Following the issuance of these memoranda, there have already been lawsuits regarding these orders. For instance, on February 11th, the American Alliance for Equal Rights filed suit against American Airlines in the United States District Court in the Northern District of Texas, alleging that the company's supplier diversity programs unlawfully excluded potential contractors on the basis of race in violation of Section 1981. The complaint notes that American Airlines explicitly reserved opportunities for businesses owned by individuals from specific racial groups while excluding others. This is an example of the type of litigation private companies may see in light of the executive orders and the current environment around DEI programs. Further, on February 2nd, the National Association of Diversity Officers in Higher Education sued President Trump and a number of federal agencies and agency heads, alleging the DEI-related executive orders violated their constitutional rights. On February 13th, the plaintiffs requested a temporary restraining order to halt the effectiveness of the executive orders. While it is too early to know where either of these cases will go, these are the types of litigations we will likely see stem from these orders. Unfortunately, the overall effect of these executive orders and the effects of the related litigation are difficult to forecast. Private employers will need to stay attuned to this developing issue. It is also important to note that while the federal government is shifting away from DEI programs, some states may be moving in the opposite direction by enacting laws that preserve DEI efforts within their jurisdictions. For example, several states have passed or are considering legislation that protects corporate DEI programs or maintains diversity requirements for public contracting. Texas employers, however, should keep in mind that the Texas legislature passed SB 17, which banned DEI programs at state public universities effective January 1st, 2024. Other states may enact similar laws restricting DEI initiatives in public institutions or state-funded organizations. Employers operating across multiple states should stay informed about conflicting state and federal policies that may impact their compliance strategies. Beyond the legal implications, employers must also consider how employees, investors, and the general public are responding to these policy changes. Many companies have already faced internal pressure from employees who support DEI programs and expect businesses to uphold their commitments to diversity and inclusion. Some organizations have publicly committed to maintaining DEI efforts despite the new federal restrictions, while others are adopting a more cautious approach to avoid legal challenges. Employers should carefully balance legal compliance with workplace morale by communicating clearly about any changes to DEI initiatives. Organizations that decide to modify their DEI programs should emphasize their commitment to workplace equity and inclusion while ensuring that all policies still comply with anti-discrimination laws. The broader implications of these executive orders remain uncertain, but they are likely to have long-term effects on workforce diversity and recruitment strategies. Employers should consider how these policies may impact talent acquisition. If DEI initiatives are scaled back, companies may need to find alternative ways to attract diverse talent without violating the law. Employee retention. A company's stance on DEI may influence employee satisfaction and retention, particularly for younger generations who prioritize workplace diversity. And corporate reputation. A public's perception of a company's diversity efforts can affect brand image, investor relations, and even customer loyalty. To navigate this evolving legal landscape, private employers should 1. Stay informed, monitor ongoing litigation and regulatory updates to understand how courts and enforcement agencies are interpreting these executive orders. 2. Review DEI policies. Conduct a legal risk assessment to ensure current programs align with federal and state anti-discrimination laws. 3. Maintain compliance and transparency. Avoid policies that could be perceived as quotas or preferential hiring practices while continuing inclusive workplace initiatives that foster equal opportunity. 4. Engage legal counsel. Given the potential for increased legal scrutiny, consult with employment law attorneys to evaluate high-risk DEI policies and ensure compliance with evolving regulations. Ultimately, the full impact of these executive orders remains uncertain. While legal challenges are underway, this issue will likely continue to evolve. Private employers should remain informed, monitor legal developments, and consult legal counsel to effectively navigate these changes. Maintaining a lawful and inclusive workforce should remain a top priority even as the regulatory environment shifts. And lastly, we'd like to talk about onboarding procedures. You should be aware of any required trainings for new hires under state law. For example, certain safety trainings are required under California law by Cal OSHA. Some states will require that new employees attend certain anti-harassment trainings within a certain time after starting employment. Likewise, if you take a training at one job and switch to another, some of that training compliance will transfer to your new job and others will not. So you will just have to look at the specific training requirements for each employee in each specific jurisdiction. All new hires should be given the opportunity to review policies, and it's the best practice to have them sign and acknowledge them where applicable. When these policies are before us in litigation, we are often looking to see whether an employee received or was aware of an employer's policy on a certain issue. While a lot of employment is at will, and practically it should not matter if the employee received the policy, having the record that an employee received certain policies or an employee's handbook or acknowledge those policies can be a helpful defense that would be available to you if you make acknowledgement a practice of reviewing your policies. Another big topic that's been in the news and is relevant to onboarding is immigration. And employers must verify that any new hires are authorized to accept employment in the United States. However, as Caroline mentioned in her strategies to mitigate bias discussion, we want to make sure that those questions that you are using to determine if someone is authorized to work in the U.S. are focused on the job. So, for example, do you require sponsorship, and not specifically asking about someone's citizenship. All U.S. employers must properly complete Form I-9s for each employee and retain them. Those retention requirements are very stringent, and if an employer is found not to have complied with their retention requirements, the Department of Homeland Security will often assess heavy penalties. Benefits, compensation, and other new employee paperwork should be completed at this stage. And a reminder, when you're completing this paperwork, that employees are required to produce both documentation evidencing citizenship and identification. Those must be reviewed by the employer in person, so scanned copies or remote examination of those identification documents are not going to be sufficient. So, as you can see, hiring can be a long and complicated process. There are many laws on both the federal and state level that employers must consider, and also regulations and requirements that may be industry specific that are impacting your specific workplace. We're hopeful that the webinar today provided you with insight, at least high level, into your legal requirements and consideration when interviewing and hiring applicants, but also some practical tools to implement and comply with hiring in the legal way. However, note that this is just an intro into all of these topics. We could do individual webinars on each of these, and it's important to consult legal counsel should you have any issues specific to your place of employment that we've discussed today. As always, we are here to help in any way. Our contact information is on the final slide. Please feel free to reach out to us. We are standing by here to hear from you. Thank you.